I knew something was wrong the moment I turned onto Maple Ridge Drive and saw my front door looking different. After 2 glorious weeks in Maui with my girlfriend Sarah, the last thing I expected was to find myself locked out of my own house in suburban Phoenix, Arizona. But there I stood at 3 in the afternoon on a sweltering July day, my key refusing to turn in what was clearly a brand new lock. My tan was still fresh, my suitcase still had sand in the wheels, and apparently, while I had been sipping Mai Tais on the beach, someone had decided I no longer deserved access to the home I had owned for 3 years. I jiggled the key again, thinking maybe I was just tired from the flight. Nothing. I tried the back door, different lock. Also would not budge. My stomach started to twist as I walked around my entire property, checking every possible entry point. Every single lock had been changed. On my house. The one I paid a mortgage on every month without fail. Then I saw it. A bright yellow notice taped to my front door, partially hidden behind the new bronze door knocker that definitely had not been there when I left. I ripped it off and read it 3 times before my brain could process what I was seeing. Notice of property securing. Due to violations of HOA Covenant Codes 3.7, 4.2, and 8.9, and failure to respond to multiple notices, the Maple Ridge Homeowners Association has exercised its right to secure this property until all fines are paid and violations are remedied. Total amount due, $4,200. Contact HOA President Patricia Winters immediately. My name is Keith Palmer, and I had just become the victim of what I would later learn was a completely illegal lockout. But standing there in my driveway with my luggage at my feet and sweat dripping down my back, all I felt was pure, unadulterated rage. I pulled out my phone and called the HOA office number listed on the notice. It rang 4 times before a chirpy voice answered. Maple Ridge HOA, this is Denise speaking. This is Keith Palmer from 847 Maple Ridge Drive. Someone changed my locks while I was on vacation and I need them changed back immediately. There was a pause, then some keyboard clicking. Oh yes, Mr. Palmer. You have several outstanding violations and have ignored multiple attempts at contact. The board voted to secure your property. You cannot legally lock me out of my own house, I said, trying to keep my voice steady. I want my keys right now. I am afraid that is not possible until you pay your outstanding fines and remedy the violations. Would you like to schedule an appointment with Mrs. Winters? No, I would like to get into my house. Today. Now. I understand your frustration, but the board has very clear policies about this. Perhaps if you had responded to any of our letters, we could have avoided this situation. What letters? I never received any letters. More keyboard clicking. We show that notices were sent on June 8th, June 15th, June 22nd, and June 29th, all to your address on file. I had left for Maui on June 30th. I want copies of these supposed violations and I want into my house. This is illegal. Sir, I would really recommend speaking with Mrs. Winters. She is available tomorrow at 10 a.m. Tomorrow? Where exactly do you expect me to sleep tonight? That is not really the association's concern, Mr. Palmer. You should have thought about that before ignoring our communications. I hung up before I said something I would regret. My hands were shaking. I had never had a single interaction with the HOA beyond paying my quarterly dues, which were automatically withdrawn from my checking account. I kept my lawn trimmed, my house painted the approved beige color, and my trash cans in the garage except on collection days. What violations could I possibly have? Sarah touched my arm. What are we going to do? I am calling a locksmith. I found one that could come within the hour. While we waited, I walked my property again, taking photos of everything. The new locks, the notice, the whole house. Something about this felt deeply wrong, and I wanted documentation. The locksmith arrived in a white van, an older guy named Tom who had probably seen everything. He took one look at the locks and whistled. "These are high-security Medico locks, commercial grade. Someone spent serious money putting these in. Can you get me inside?" "Sure, but I gotta tell you, if someone else had these installed and has a legal right to the property, you could get in trouble for this. I own this house. I have the mortgage documents in my email if you need to see them. Someone changed my locks without my permission while I was on vacation." Tom shook his head. "HOA. How did you know?" "Seen it a few times. They are not supposed to do this, you know. Real gray area legally, and by gray area I mean totally illegal in most cases. But some of these HOAs think they are above the law." He pulled out his tools. "This is going to take a while and it is going to cost you. These locks are not cheap to crack." An hour and $600 later, I was back inside my own home. Everything looked exactly as I had left it, which was somehow more disturbing than if things had been moved around. They had just locked me out, nothing more, like I was some kind of trespasser instead of the person who had lived here for 3 years. I immediately went to my mail basket by the door where my neighbor's teenage son had been collecting my mail while I was gone. There were the usual bills, some catalogs, junk mail, and 4 letters from the Maple Ridge HOA, all still sealed. I ripped open the first one, dated June 8th. "Dear Mr. Palmer, it has come to the attention of the HOA board that you have committed the following violations. Violation 3.7 regarding unauthorized exterior modifications. Violation 4.2 regarding improper window coverings. And violation 8.9 regarding prohibited decorative items. You have 14 days to remedy these violations or face fines of $250 per day per violation. Please contact the HOA office immediately to discuss compliance." I read it 3 times. Unauthorized exterior modifications. The only thing I had done to my house in the last 6 months was replace a broken porch light with an identical model. Improper window coverings. I had white blinds in every window, same as half the neighborhood. Prohibited decorative items. I looked around my front yard. I had a mailbox, a doormat, a small ceramic pot with a cactus that had been there since I moved in. What was prohibited? The second letter, dated June 15th, was more aggressive. "Mr. Palmer, you have failed to respond to our previous notice. Your violations remain uncorrected. Fines have begun accruing. You now owe $750. Immediate payment and compliance are required." The third letter from June 22nd increased the amount to $2,000 and threatened further action if I did not comply. The fourth letter, dated June 29th, the day before I left for vacation, informed me that the board had voted to secure my property and that I now owed over $4,000. I had never seen any of these letters because they had all arrived after my neighbor's son had started collecting my mail, and I had not checked my mail basket before leaving. I had been too busy packing and getting ready for the first real vacation I had taken in 2 years. Sarah read over my shoulder. "This is insane. What violations are they even talking about?" I walked outside and studied my house with fresh eyes. Then I saw it. The porch light I had replaced was brass instead of the bronze that had been there before. I had not even thought about it when I bought it at Home Depot. It was just a porch light. But apparently, brass was not an approved finish. The window coverings took longer to figure out. I walked inside and looked at my front windows. White blinds, nothing special. Then I noticed that in my bedroom, which faced the street, I had hung a decorative tapestry on the wall behind my bed. From the outside, You could see a hint of color through the white blinds if you really looked. That was apparently an improper window covering, because it showed something other than white or beige from the exterior. The decorative item was even more ridiculous. I had a small garden gnome tucked next to my mailbox post. My mom had given it to me as a housewarming gift. It was maybe 8 inches tall. But apparently, garden gnomes were on the prohibited decorative items list that I had never been given when I moved in. So let me get this straight. Because of a brass porch light, a tapestry that was barely visible through closed blinds, and a tiny garden gnome, the HOA thought it was appropriate to change my locks and charge me over $4,000. And they had done all of this in the 2 weeks I was on vacation, giving me zero opportunity to actually fix any of these problems. I called a lawyer that evening. His name was Robert Chen, and he specialized in HOA disputes. I found him through a frantic Google search, and was lucky he agreed to a phone consultation on short notice. "They did what?" he asked after I explained the situation. "Changed my locks while I was on vacation. I have the notice and the letters right here." "Mr. Palmer, what they did is called an illegal lockout, and it is very much against the law in Arizona. HOAs have the right to fine homeowners for violations, and in extreme cases, they can place a lien on the property. But they absolutely cannot prevent you from accessing your own home. That is a criminal act." My heart rate picked up. Criminal? Yes. What they did could constitute illegal eviction, trespassing, or even extortion depending on how we frame it. Arizona has very specific landlord-tenant laws that protect people from this kind of thing, and while you are not technically a tenant, the same principles apply. No one can lock you out of your residence without a court order. Even if you had not paid your HOA dues in years, they still could not do this. So what do I do? First, document everything. Take photos, keep all the letters, get a copy of your HOA covenants and bylaws. Second, I want you to send a demand letter to the HOA demanding they reimburse you for the locksmith. Immediately rescind all fines, and provide written confirmation that they will not retaliate against you. Third, if they do not comply within 7 days, we file a lawsuit. How much is this going to cost me? My retainer is $3,000, but Mr. Palmer, I have to tell you, cases like this often result in significant damages. If we can prove they acted willfully and maliciously, which it sounds like they did, you could be entitled to actual damages, punitive damages, and attorney fees. These HOAs think they can bully homeowners, but the law is very clear that they cannot. I hired him on the spot. The next morning, I showed up at the HOA office at 9 a.m., an hour before my so-called appointment. The office was in a small building at the entrance to the neighborhood, a beige stucco structure that matched all the houses. Inside, a young woman sat at a desk surrounded by filing cabinets. "This must be Denise from the phone. Hi, I am Keith Palmer. I am here to see Patricia Winters." Denise looked up, startled. "Your appointment is not until 10. "I do not care. I want to see her now." "She is not available right now." "Then I will wait." I sat down in one of the uncomfortable plastic chairs and crossed my arms. Denise looked nervous but picked up her phone and spoke quietly into it. 2 minutes later, a door opened and out walked what could only be Patricia Winters. She was exactly what I expected. Mid-50s, blonde hair in a tight bob, wearing a pantsuit that probably cost more than my mortgage payment, and an expression like she smelled something bad. Her face had that tight, pinched quality of someone who had spent years perfecting the art of disapproval. "Mr. Palmer, you are early. You locked me out of my house. You violated HOA covenants and ignored multiple notices. The board voted unanimously to take action. You cannot legally lock someone out of their own home. What you did is a crime. Patricia's expression did not change. We acted within our rights as outlined in the HOA governing documents that you agreed to when you purchased your property. If you had simply responded to our letters and paid your fines, none of this would have been necessary. I was on vacation. I never saw your letters until yesterday. That is not the HOA's problem. Homeowners are responsible for monitoring their mail and complying with all covenants. You changed my locks. You had no right to do that. We had every right. You violated multiple covenants and ignored our attempts at contact. The board determined that securing the property was necessary to ensure compliance. I pulled out my phone and opened the voice recorder. So you are admitting that you changed the locks on my house without my permission? Patricia's eyes narrowed. Do not think you can intimidate me, Mr. Palmer. I have been HOA president for 8 years and I have dealt with far worse than you. You can either pay your fines and fix your violations, or we will place a lien on your property and eventually foreclose. Your choice. You are not going to do any of that because what you did is illegal and I have already hired a lawyer. You are going to rescind all fines, reimburse me for my locksmith costs, and apologize, or I am going to sue you and this HOA for everything you are worth. For the first time, Patricia's composure cracked slightly. You cannot sue the HOA. We have legal immunity for actions taken in good faith. Changing someone's locks is not good faith. It is a criminal act. My lawyer is preparing a demand letter right now, and if you do not comply, I will see you in court. I walked out before she could respond. My hands were shaking, but I felt oddly empowered. For the first time since I had arrived home yesterday, I felt like I had some control over the situation. Robert sent the demand letter 2 days later via certified mail. It was 3 pages of legal language that boiled down to: rescind the fines, reimburse Keith Palmer for all costs including the locksmith and legal fees, provide written confirmation of no retaliation, or face a lawsuit for illegal lockout, emotional distress, and punitive damages. The HOA had 7 days to respond. They responded in 5 days, and their answer was essentially no. The letter, signed by Patricia Winters and the HOA's lawyer, a guy named Mark Stevens, claimed that the HOA had acted within its rights, that I had violated multiple covenants, and that they would not be rescinding any fines or providing any reimbursement. They did, however, graciously offer to set up a payment plan for my $4,000 debt. They really think they are going to win this, I told Robert over the phone. Then we file suit. I will have the complaint ready by end of day tomorrow. We are going to sue for illegal lockout, breach of contract, emotional distress, and punitive damages. I am also going to request a preliminary injunction preventing them from taking any further action against you while the case is pending. How long is this going to take? HOA cases can take anywhere from 6 months to 2 years depending on how much they fight. But Mr. Palmer, I have a feeling this one is going to settle. Once they realize how badly they messed up and how much it is going to cost them, they will want to make this go away quietly. The lawsuit was filed in Maricopa County Superior Court 3 days later. I sued the Maple Ridge Homeowners Association, Patricia Winters personally, and the other 4 board members: Linda Sheffield, Gary Morrison, Denise Kramer, not the receptionist, a different Denise, and Tom Paulson. The total amount I was seeking was $50,000 in actual and punitive damages, plus attorney fees and costs. The local news picked up the story 2 weeks later. A reporter named Jessica Tang from Channel 12 somehow got wind of the lawsuit and called me for an interview. I almost said no, but Robert encouraged me to do it. Public pressure can be a powerful tool in these cases, he said. HOAs hate negative publicity. So I sat down with Jessica in my living room and told her everything. She filmed the new locks, the notice that had been on my door, the ridiculous violations. The segment aired on the 6 o'clock news 2 days later under the headline "Local HOA Locks Homeowner Out During Vacation." The story went viral. Within 24 hours, it had been picked up by national news outlets, shared thousands of times on social media, and generated hundreds of comments from people sharing their own HOA horror stories. Apparently, I was not alone in being victimized by an overzealous homeowners association. Patricia Winters did not appreciate the attention. She sent me a cease and desist letter demanding I stop talking to the media and remove all defamatory statements. Robert responded with a letter explaining that truth is an absolute defense to defamation, and that I would be happy to continue sharing my story with anyone who wanted to listen. The preliminary injunction hearing was scheduled for early September, about 6 weeks after the lockout. Robert filed a motion asking the judge to prevent the HOA from placing a lien on my property, attempting to foreclose, or taking any other punitive action while the lawsuit was pending. The HOA opposed the motion, arguing that I was a scofflaw who refused to comply with community standards. Judge Michelle Alvarez heard arguments on a Thursday morning. The courtroom was small and stuffy, and I sat behind Robert at the plaintiff's table while Mark Stevens, the HOA's lawyer, stood at the defense table shuffling papers. "Your Honor," Robert began, "this is a straightforward case of illegal lockout. While my client was on vacation, the HOA changed the locks on his house without permission, without a court order, and without any legal basis to do so. They then demanded over $4,000 to give him access to his own home. This is not only illegal, it is potentially criminal." Judge Alvarez, a stern woman in her 60s, looked at the HOA's lawyer. "Counselor, did your clients change the locks on the plaintiff's house?" Mark Stevens cleared his throat. "Yes, Your Honor, but they did so pursuant to the HOA covenants, which give the association the right to take reasonable measures to enforce compliance with community standards." "Show me where in the covenants it says you can lock someone out of their house." "Well, it does not explicitly say that, but Section 12.4 states that the HOA may take all reasonable and necessary measures to ensure compliance. Locking someone out of their home is neither reasonable nor necessary, Counselor. In fact, it is illegal. Arizona law is very clear that you cannot prevent someone from accessing their residence without a court order, regardless of what your HOA covenants say. HOA covenants do not supersede state law." "Your Honor, with respect, the plaintiff violated multiple covenants and ignored numerous attempts at contact. The HOA had no choice but to take action. They had plenty of choices. They could have continued sending letters. They could have assessed fines. They could have placed a lien on the property and eventually sought foreclosure through proper legal channels. What they could not do is change his locks. Motion for preliminary injunction is granted. The HOA is hereby prohibited from placing any liens, attempting foreclosure, or taking any other action against the plaintiff's property while this case is pending." It was a small victory, but an important one. More importantly, it signaled that the judge understood what had happened here and was not going to let the HOA get away with it. Discovery began in October. Robert sent interrogatories and document requests to the HOA demanding copies of all communications, board meeting minutes, financial records, and anything else related to my case. What came back was illuminating. The board meeting minutes from late June showed that Patricia had called an emergency meeting specifically to discuss the Keith Palmer situation. According to the minutes, Patricia had told the board that I was willfully ignoring their letters, and that they needed to send a strong message to the rest of the community that violations would not be tolerated. The vote to change my locks had been 4-1, with Tom Paulson being the sole dissent. He had argued that changing someone's locks seemed legally questionable, and they should consult their lawyer first. Patricia had overruled him, saying that the covenants gave them clear authority. Except they had never consulted their lawyer before doing it. Mark Stevens had only been brought in after I hired Robert and threatened to sue. In other words, Patricia had acted unilaterally, convinced the rest of the board to go along with it, and never bothered to check if what they were doing was actually legal. Robert also discovered that this was not the first time Patricia had pushed the boundaries of the HOA's authority. Over the past 8 years, she had initiated dozens of violation proceedings against homeowners, often for minor issues like the wrong shade of beige paint or mailbox numbers that were half an inch too large. Several homeowners had paid significant fines rather than fight her. One couple had even sold their house and moved away after Patricia made their lives miserable over a rose bush that was apparently the wrong color. But I was the first person she had actually locked out, and that was going to be her downfall. My deposition was scheduled for November. I sat in a conference room at Mark Stevens' law office and answered questions for 4 hours. Most of it was straightforward. When did I buy the house? Did I receive the HOA covenants? Had I read them? When did I go on vacation? When did I discover the locks had been changed? But then Mark started asking about my willful refusal to comply with the violations. Mr. Palmer, you received the first letter on June 8th, correct? No, I received it in mid-July when I got home from vacation. But it was sent to you on June 8th. I did not see it until July. But you were aware that you had installed a brass porch light in violation of the covenants. I was not aware that brass was prohibited. The light that broke was bronze, and I replaced it with what I thought was a similar light. I did not know there was a difference. You did not read the covenants before making modifications to your home. It was a porch light. I did not think I needed HOA approval to replace a broken porch light with a nearly identical one. The covenants clearly state that all exterior modifications require approval. Does changing a light bulb require approval? What about replacing a doormat? Where exactly is the line? Mark did not like that. Mr. Palmer, are you saying you do not think you need to follow the rules? I am saying the rules are unreasonable and enforced selectively. Half the houses in this neighborhood have different porch lights. Why was I singled out? That is not relevant to this deposition. It is absolutely relevant. Your client did not change my locks because of a porch light. She did it because she is on a power trip and thought she could get away with it. Robert touched my arm, a signal to dial it back. I took a breath. The rest of the deposition was more of the same. Mark tried to paint me as a difficult homeowner who refused to follow rules, while I maintained that I had done nothing wrong and had been illegally locked out of my home. By the end, I was exhausted and frustrated. Patricia's deposition was 2 weeks later, and I insisted on being there. Robert tried to talk me out of it, saying it would just upset me, but I wanted to watch her try to justify what she had done. She showed up in another expensive pantsuit, her blonde hair perfect, her makeup flawless. She sat down across from Robert and folded her hands like she was about to lead a board meeting. Robert started with softball questions about her background and how long she had been HOA president. Then he got to the meat of it. Mrs. Winters, why did you decide to change Mr. Palmer's locks? He had multiple violations and was ignoring our attempts to contact him. We needed to ensure compliance. How does changing his locks ensure compliance? It sends a message that violations will not be tolerated. Did you consult with your attorney before changing the locks? A pause. No. Why not? I did not think it was necessary. The covenants give us broad authority to enforce compliance. Where in the covenants does it say you can change someone's locks? Section 12.4 allows us to take reasonable measures. Do you think locking someone out of their home is reasonable? In this case, yes. Mr. Palmer had ignored 4 letters and made no effort to comply. Mrs. Winters, you sent those 4 letters over the course of 28 days, correct? Yes. And Mr. Palmer was on vacation for the last 14 of those days. I was not aware he was on vacation. Did you make any effort to find out? Did you knock on his door, call him, email him? We sent letters to his address on file. That is our standard procedure. So you did not actually know if he was receiving your letters or not. It is his responsibility to monitor his mail, even if he is out of town. Yes. Mrs. Winters, did you know that changing someone's locks without their permission is illegal in Arizona? Another pause. I was not aware of that specific statute, but you are now. Yes. And you still maintain that what you did was appropriate. I maintain that we acted within our authority as outlined in the HOA covenants, even though it violated state law. The covenants are a legally binding contract that Mr. Palmer agreed to when he purchased his property. Contracts cannot violate state law, Mrs. Winters. You cannot agree to something that is illegal. I disagree. You disagree that HOA covenants have to comply with state law. I disagree that what we did was illegal. We were protecting the community. By locking someone out of their house, by enforcing standards that everyone agreed to follow. It went on like that for 3 hours. Patricia refused to admit any wrongdoing, insisted that she had acted appropriately, and showed zero remorse for what she had done to me. By the end, even Robert looked frustrated. She is unbelievable, I said as we walked to our cars afterward. She is also screwed, Robert replied. That deposition is going to destroy her in court. She admitted everything we need to prove our case and showed no remorse. A jury is going to hate her. The HOA made a settlement offer in January, 9 months after the lockout. They offered to rescind all fines and pay $5,000 to cover my locksmith costs and attorney fees to date. Tell them to go to hell, I said when Robert called with the offer. That was my instinct too. They are lowballing you because they think you will take the easy money and go away. But if we go to trial, I think we can get significantly more. Then we go to trial. Robert countered with a demand for $45,000 plus attorney fees. The HOA rejected it. Trial was scheduled for April, nearly 10 months after the lockout. As the date approached, Robert and I spent hours preparing. We had boxes of evidence. The letters, the notice from my door, photos of the locks, bank records showing I had always paid my HOA dues on time, the board meeting minutes, Patricia's deposition testimony. We also had something else. 3 other homeowners from Maple Ridge who had agreed to testify about Patricia's aggressive enforcement tactics. One woman, Maria Gonzalez, had been fined $1,500 for planting flowers that were not on the approved list. Another couple, the Johnsons, had been threatened with foreclosure over a garden hose that was visible from the street. And Tom Paulson, the board member who had voted against changing my locks, had resigned in protest and agreed to testify about Patricia's domineering behavior. The trial began on a Monday morning in mid-April. Judge Alvarez presided, and we had a jury of 8 people, 5 women, 3 men, ranging in age from late 20s to early 70s. Robert's opening statement was powerful. Ladies and gentlemen, this case is about a simple question. Can your homeowners association lock you out of your own home because they do not like your porch light? The answer, under Arizona law, is absolutely not. But that is exactly what happened to Keith Palmer. While he was on vacation celebrating his girlfriend's birthday, the Maple Ridge HOA changed every lock on his house and demanded over $4,000 to let him back in. They did this without a court order, without his permission, and without any legal authority whatsoever. What they did was not just wrong, it was illegal, and we are here today to hold them accountable. Mark Stevens' opening statement tried to paint me as a scofflaw who had ignored multiple warnings. The HOA has rules for a reason, to maintain property values and ensure a safe, attractive community. Mr. Palmer knew the rules when he bought his house. He violated those rules, and when the HOA tried to work with him, he ignored them. The HOA had no choice but to take action. The first witness was me. Robert walked me through the entire timeline. Buying the house, replacing the porch light, going on vacation, coming home to find new locks, calling the HOA, hiring a locksmith. I kept my testimony factual and emotional at the same time, describing the shock and violation I felt when I realized I could not get into my own home. Mark's cross-examination tried to make me look unreasonable. Mr. Palmer, you admit that you violated the HOA covenants by installing a brass porch light. I replaced a broken light fixture with what I thought was an acceptable replacement. If brass was not allowed, no one ever told me that. It is in the covenants, is it not? There are 87 pages of covenants. I am not sure anyone has memorized all of them. But you agreed to follow them when you bought your house. I agreed to be a good neighbor and keep my property maintained. I did not agree to let the HOA lock me out because they did not like my light fixture. The jury seemed sympathetic. Next up was Tom Paulson, the former board member. He was a quiet guy in his mid-60s who had lived in Maple Ridge for 12 years. He testified that he had been uncomfortable with Patricia's aggressive enforcement tactics for years, but had stayed on the board hoping to be a moderating influence. When she proposed changing Mr. Palmer's locks, I immediately said it was a bad idea, he testified. I told the board we should consult our lawyer first, but Patricia said we did not need to, that the covenants gave us clear authority. I voted no, but I was outvoted 4-1. Why did you resign? Robert asked. Because I realized Patricia was not interested in serving the community. She was interested in control, and I did not want to be part of that anymore. Mark tried to discredit him on cross-examination, suggesting he had a grudge against Patricia. Tom calmly replied, I do not have a grudge, I have principles. What was done to Mr. Palmer was wrong, and I could not be part of an organization that thought it was acceptable. The other homeowners testified about their experiences with Patricia. Maria Gonzalez broke down in tears describing how Patricia had called the flowers in her garden garish and threatened to fine her until she removed them. They were just petunias, she sobbed. My mother planted petunias in her garden when I was growing up. I wanted my kids to have that same memory. The Johnsons testified about being photographed by Patricia while they were in their backyard, documenting code violations. It felt like harassment, Mrs. Johnson said. We could not even spend time in our own yard without worrying that she was watching us. By the time Patricia took the stand on day 3, the jury already looked ready to convict her. Robert's direct examination was methodical and devastating. He walked her through every decision, every letter, every fine, culminating in the decision to change my locks. Mrs. Winters, you testified in your deposition that you thought changing Mr. Palmer's locks was reasonable. Do you still believe that? Patricia lifted her chin. Yes. We needed to ensure compliance. You have heard testimony that what you did was illegal under Arizona law. Does that change your opinion? I do not agree that it was illegal. We acted pursuant to our governing documents. So even knowing what you know now, you would do it again. A long pause. If necessary, yes. I saw several jurors exchange glances. That was the moment I knew we had won. Mark tried to rehabilitate her on cross-examination, but there was not much he could do. Patricia was her own worst enemy. She came across as cold, arrogant, and utterly convinced of her own righteousness. She did not see homeowners as people she served. She saw them as subjects she ruled. Closing arguments were on day 4. Robert's closing was passionate, summarizing all the evidence and reminding the jury that this was about fundamental rights. A person's home is their castle. It is where they should feel safe and secure. The HOA took that away from Keith Palmer, not because he was a bad neighbor or a danger to the community, but because they did not like his porch light. That is not acceptable. That is not legal. And you have the power to send a message that this behavior will not be tolerated. The jury deliberated for 5 hours. When they came back, the verdict was unanimous, in favor of Keith Palmer on all counts. They awarded me $12,000 in actual damages, covering my locksmith costs, attorney fees to date, and emotional distress. But the big number was the punitive damages. $85,000, meant to punish the HOA and deter similar conduct in the future. Total award, $97,000. I sat in stunned silence as the judge read the verdict. $97,000. For changing my locks over a brass porch light, Patricia's face went white. The other board members looked shell-shocked. Mark Stevens gathered his papers with the tight expression of a lawyer who knew he had lost badly. Outside the courthouse, Robert shook my hand. Congratulations, Keith. You just taught that HOA a very expensive lesson. What happens now? They will probably appeal, but they are not going to win. The evidence was overwhelming and Patricia's testimony sealed their fate. More likely, they will try to negotiate the amount down, but that verdict is going to stand. The local news covered the verdict that evening. Jessica Tang interviewed me on the courthouse steps, and I gave a brief statement. I hope this sends a message to HOAs everywhere that they cannot abuse their power. Homeowners have rights, and those rights do not disappear just because you live in a community with covenants. The HOA did try to appeal, but their appeal was denied 3 months later. The appeals court found that the jury verdict was supported by the evidence, and that the punitive damages were appropriate given the HOA's willful misconduct. In August, 14 months after the lockout, I received a check for $97,000 from the Maple Ridge HOA's insurance company. They had paid the judgment to avoid further litigation, but the story did not end there. The homeowners of Maple Ridge, emboldened by my victory, called a special election and voted Patricia Winters out as HOA president. She was replaced by Tom Paulson, who immediately began reforming the HOA's enforcement policies. The new board voted to eliminate most of the nitpicky rules about paint colors and decorative items, focusing instead on genuine health and safety issues. Patricia, humiliated by the verdict and her removal from the board, put her house up for sale and moved out of the neighborhood within 3 months. I heard through the grapevine that she moved to Scottsdale and joined a different HOA board, but I never confirmed it. As for me, I used part of the judgment money to pay off a chunk of my mortgage. I also installed a new porch light, a beautiful bronze fixture that was absolutely, definitely, 100% in compliance with HOA covenants. Not that anyone was checking anymore. The garden gnome stayed exactly where it was. I learned a lot from the experience. I learned that HOAs, while well-intentioned in theory, can become tools of oppression in the wrong hands. I learned that standing up for your rights is exhausting and expensive, but ultimately worth it. And I learned that there are still judges and juries out there who understand that a person's home is sacred, and no HOA has the right to take that away over a porch light. Sarah and I got engaged about 6 months after the trial. We planned a wedding for the following spring, and we decided to start house hunting for a new place. But this time, we had one non-negotiable requirement: no HOA. We eventually found a beautiful house on 2 acres outside of Phoenix, far from any homeowners association. It has a brass porch light, colorful window coverings, and an entire collection of garden gnomes in the front yard. And no one can tell me to change any of it. The whole ordeal with Patricia and the Maple Ridge HOA taught me something fundamental about American property rights. When you buy a home, you are not just purchasing a structure, you are buying a piece of the American dream. The idea that you can lock your door at night and know that your home is your sanctuary is foundational to our society. HOAs exist to maintain property values and create pleasant communities, and most of them do a decent job of balancing rules with common sense. But when an HOA board member like Patricia Winters gets a taste of power and decides that enforcement is more important than fairness, the whole system breaks down. I think about those 2 weeks in Maui sometimes, sipping drinks on the beach while Patricia was orchestrating her little power playback in Phoenix. If I had been home when those letters arrived, I probably would have just fixed the violations and moved on with my life. A different porch light, moving the tapestry, putting away the garden gnome. It would have taken me an afternoon and cost maybe $100. But because I was on vacation, because I did not see those letters, Patricia escalated to the nuclear option. And that is what really gets me. She could have waited. When she did not get a response to her letters, she could have made a phone call. She could have knocked on my door and realized no one was home. She could have asked my neighbors if they knew where I was. Instead, she saw an opportunity to send a message to the community, and she took it without considering the legal or ethical implications. The irony is that by trying to make an example out of me, she made an example of herself. The verdict in my case became a cautionary tale in HOA communities across Arizona and beyond. Robert told me that he got calls from at least a dozen lawyers asking for copies of our briefs and trial strategy because they had clients in similar situations. The case even got written up in a legal journal as an example of HOA overreach and the importance of understanding landlord-tenant laws. I stayed in touch with Tom Paulson after the trial. He told me that the new HOA board had reduced annual dues by 30% and redirected the savings from Patricia's aggressive enforcement regime toward actual community improvements like playground equipment and neighborhood events. The change in culture was dramatic. People actually started attending HOA meetings again instead of avoiding them out of fear. Maria Gonzalez replanted her petunias, and the neighborhood looked better for it. The Johnsons set up a barbecue area in their backyard without worrying about Patricia photographing them. And several other homeowners who had been living in fear of violation notices finally felt like they could enjoy their homes again. One of the most satisfying moments came about a year after the verdict when I got a letter from the new HOA board, formally apologizing for what had happened and thanking me for standing up to Patricia's abuse of power. They included a refund of 2 years' worth of HOA dues and a promise that no homeowner would ever be treated that way again. I framed that letter and hung it in my home office as a reminder that sometimes fighting the system actually works. The legal community also took notice. Robert Chen became something of a celebrity in HOA law circles, and his practice expanded significantly. He told me that my case had given him the ammunition he needed to take on other abusive HOAs, and he had won several more significant verdicts in the following years. We stayed friends, and he even came to my wedding. Speaking of the wedding, Sarah and I made sure to invite Tom Paulson and several of the other Maple Ridge homeowners who had supported me during the trial. It felt important to celebrate with people who understood what we had been through. Maria Gonzalez brought her kids, who presented us with a beautiful bouquet of petunias that made everyone laugh and cry at the same time. Looking back now, 3 years after the lockout, I can honestly say it was one of the worst and best experiences of my life. Worst because of the stress, the violation, the sheer absurdity of being locked out of my own home over a porch light. Best because it taught me that I was stronger than I thought, that the legal system can work when you have right on your side, and that standing up to bullies, even when they have institutional power behind them, is always worth it. I also learned to be more careful about HOA covenants. When Sarah and I bought our new house, we read every single line of every single document, even though there was no HOA. We wanted to understand exactly what we were agreeing to. And I have become something of an advocate for HOA reform, speaking at community meetings and writing op-eds about the need for better oversight and homeowner protections. The brass porch light is still a running joke in my family. My mom, who felt terrible about the garden gnome situation even though it was not her fault, now gives me intentionally tacky lawn ornaments every Christmas. I have a collection of pink flamingos, ceramic frogs, and yes, more garden gnomes than any one person needs. They are all proudly displayed on our property, and I smile every time I see them. Patricia Winters became a cautionary tale, but I try not to think about her too much. I heard she tried to sue me for defamation after the trial, but her lawyer talked her out of it when he explained that truth is an absolute defense. I like to imagine she is somewhere right now, probably terrorizing a new neighborhood with her measuring tape and violation notices, but hopefully someone will stand up to her like I did. The money from the judgment changed my life in practical ways. Beyond paying down the mortgage, Sarah and I were able to put a down payment on our new house, take a honeymoon to New Zealand, and start a small emergency fund. But the real value was not financial. It was knowing that I had fought for something important and won. That I had not let Patricia Winters, or the Maple Ridge HOA board, intimidate me into accepting something that was fundamentally wrong. I think about the other homeowners in communities across America who might be dealing with similar situations right now. Someone whose HOA is fining them for a mailbox that is the wrong shade of black, or threatening them over a rose bush, or demanding they remove a basketball hoop their kids love. I hope my story gives them the courage to push back, to hire a lawyer if necessary, to stand up for their rights. Because here is the thing, most HOAs will back down when confronted with actual legal action. They are run by volunteers who do not want the hassle and expense of a lawsuit, especially one they are likely to lose. Patricia Winters was an exception, someone so convinced of her own righteousness that she could not see reason. But even she ultimately lost, and lost big. The legal precedent from my case has been cited in at least 6 other HOA lawsuits that I know of, including one in Nevada, where an HOA tried to foreclose on a homeowner over unpaid fines that were disputed. The homeowner's lawyer cited my case as evidence that HOAs cannot act outside the bounds of state law, no matter what their covenants say, and the judge agreed. That homeowner kept his house. Robert told me that was the real victory. Not just my $97,000 judgment, but the message it sent to HOAs everywhere. You cannot do whatever you want. You have to follow the law. You have to treat homeowners with basic respect and dignity. And if you do not, there will be consequences. I drive by my old house in Maple Ridge sometimes, just out of curiosity. The new owners seem happy. They have a bronze porch light, and I like to think Tom Paulson's reformed HOA board is treating them fairly. The neighborhood looks good, maybe even better than when Patricia was in charge, because people seem more relaxed, more willing to personalize their homes within reasonable bounds. My new house is everything I wanted. The 2 acres give Sarah and me plenty of space and privacy. We have a vegetable garden, a small orchard, chickens in a coop out back. We can do whatever we want with our property because there is no HOA to tell us otherwise. And while I know HOAs can serve a valuable purpose in the right circumstances, I will never voluntarily live in one again. The most surreal part of the whole experience was becoming a minor celebrity in the anti-HOA community. I got interviewed by several podcasts and YouTube channels that focus on HOA horror stories. My story resonated because it was so egregious, so clearly wrong, that even people who generally support HOAs could see that Patricia had crossed a line. One interview I did was for a documentary about HOA abuse that aired on a streaming service. They interviewed me, Tom Paulson, Maria Gonzalez, and several other people who had dealt with nightmare HOAs. The documentary got good reviews and sparked a broader conversation about the need for HOA reform and better state oversight. Several state legislators reached out to me asking for input on proposed reforms. I testified before the Arizona State Legislature in support of a bill that would strengthen homeowner protections and create clearer guidelines for HOA enforcement. The bill passed, and the governor signed it into law. That was incredibly gratifying. To know that my awful experience had led to actual systemic change that would protect other homeowners felt like justice on a scale I had never imagined when I first came home from Maui to find new locks on my door. Sarah likes to joke that Patricia Winters inadvertently did us a huge favor by being so unreasonable. If she had just been a normal level of annoying, we might still be living in Maple Ridge, paying HOA dues, and worrying about whether our lawn was exactly 2.5 inches tall, as specified in the covenants. Instead, we have our dream house with no HOA, a substantial amount of money in the bank from the judgment, and a story we will be telling our grandkids someday. The story of how we learned that standing up for yourself matters, even when the opponent has institutional power. The story of how one person's abuse of authority led to their downfall and meaningful reform. The story of a brass porch light and a garden gnome that changed everything. On the 3-year anniversary of the lockout, Sarah and I threw a party at our new house. We invited Robert Chen, Tom Paulson, Maria Gonzalez, the Johnsons, and everyone else who had supported us through the ordeal. We grilled steaks, drank wine, and laughed about how far we had come. Tom gave a toast thanking me for having the courage to stand up to Patricia, and I gave a toast thanking everyone for standing with me. As the sun set over our 2 acres, and our ridiculous collection of garden gnomes cast long shadows across the lawn, I felt genuinely happy. Not just because of the money or the legal victory, but because I had learned something important about myself and about the world. I had learned that ordinary people can fight powerful institutions and win. That justice, while slow and imperfect, is still possible. And that sometimes the most important thing you can do is refuse to back down when you know you are right. The brass porch light still makes me smile every time I see it. Not because of what it is, but because of what it represents. The absurdity of Patricia's priorities, the cascade of events it triggered, and ultimately, the triumph of common sense over bureaucratic tyranny. It is just a light fixture, but it changed my life. If I could go back and give myself advice on that day I came home from Maui to find new locks on my door, I would say this: document everything, hire a good lawyer, trust the process, and do not back down. What Patricia did was not just wrong or illegal, it was a violation of something fundamental. And while fighting back was exhausting and expensive and stressful, it was worth every penny and every sleepless night. Because at the end of the day, your home is more than just a building. It is your sanctuary, your investment, your piece of the American dream. And no HOA, no matter how many pages of covenants they have, has the right to take that away from you. I never wanted to be the guy who sued his HOA. I wanted to live quietly, mow my lawn, and enjoy my life. But Patricia Winters made that impossible, and in doing so, she created her own nemesis. I hope she learned from the experience, but honestly, I doubt it. People like her rarely do. What I know for certain is that I learned from it. I learned to stand up for myself, to trust my instincts when something feels wrong, and to never underestimate the power of persistence. The legal system is not perfect, but it can work when you have the facts on your side and the determination to see things through. 3 years later, I am living my best life in a house with no HOA restrictions, with a wonderful wife, and with the satisfaction of knowing that I made a difference not just for myself, but for other homeowners who were suffering under similar tyranny. Patricia Winters changed my locks thinking she was teaching me a lesson. Instead, I taught her one, and it cost her dearly. And every time I flip on that brass porch light, I smile and remember that sometimes justice does prevail.